Thank you. Thank you for inviting me today. It's really an honor to be with these other panelists on this important topic. The timing of the hearing is important. It's clear that in recent years, the government of India has been engaging in increasingly severe crackdowns on freedom of speech under the ruling BJP government. They're now routinely responding to peaceful critics with abusive, excessive legal actions. And the focus today is on anti-terrorism provisions, but the crackdown is broader, as several panelists have noted. Tax authorities and various regulators conducting arbitrary investigations as a form of harassment, police undertaking unjustified inquiries and raids based on complaints by BJP supporters, the allegations of sedition. We could go on and on. Many of these laws and some of the provisions of the anti-terrorism laws were enacted under previous governments. But as Human Rights Watch stated when those laws were adopted, and we say again today, they don't comply with international norms or India's obligations under international human rights law, which is what I want to talk about today. But make no mistake, the current government is using these provisions more aggressively to criminalize peaceful dissent and stifle press freedom and undermine rights to freedom and freedom of expression and peaceful assembly. So look, the focus is on the terrorism law, the Unlawful Activities Prevention Act, the UAPA. I'm going to focus on how that law falls short of international human rights standards. Look, we can all acknowledge that governments have a responsibility to ensure public safety, but the current government is largely using the UAPA not to protect its citizens or national security, but rather to target human rights defenders and journalists and critics of the government, as well as members of marginalized groups, including Dalits, tribal communities, and religious minorities, in particular Muslims. But in any case, regardless of their intentions, the government's intentions, and the subject matter of the cases they brought, under international human rights law, counterterrorism legislation can't be as excessively broad and vaguely worded as the UAPA is. The International Covenant on Civil and Political Rights, the ICCPR, to which India is a state party, outlines the fundamental due process and fair trial protections that are applicable in all times in all countries that have signed that treaty, even during states of emergency. And as the UN Security Council, Resolution 1456 mentions in the context of counterterrorism legislation, counterterrorism measures that countries adopt must comply with their international obligations under human rights law. Well, India has failed in those regards, under those standards, as Ms. Jaising just noted, and the other panelists talked about. Under the UAPA, terrorism is defined in an entirely vague and overbroad manner, encompassing a wide range of activities, including non-violent activities, including political protest by minority populations and civil society groups. As Ms. Jaising noted, the law criminalizes any act, quote, likely to threaten the unity, integrity, security, or sovereignty of India, or likely to cause even something relatively unterrifying, like the disruption of supplies or services central to the life of the community. Let me underline Ms. Jaising's point. This language is incredibly vague and overbroad and violates international human rights norms that I just cited. And indeed, any lawyer, not just a human rights lawyer, can see how open the language is. Beyond criminalizing violent acts, it criminalizes any act or activity at all that might threaten India's unity or integrity. I mean, what are such acts? Reading a Bertolt Brecht poem? Engaging in any kind of criticism of the government? Is this briefing a violation of the law? Any activity at all that threatens India's unity, whatever the means, or arguably offends somebody somewhere in India, is criminal, potentially, under the vagueness of this law. But it gets worse. The law also contains all of the major procedural problems that the other panelists have mentioned. Banning an organization, making membership of groups a criminal offense, conducting warrantless searches, seizures, and arrests, compelling third parties to provide information without a court order, creating special courts with in-camera hearings using secret witnesses and evidence. And most troublingly of all, the way the UAPA allows detention without charge for up to 180 days and creates a small presumption against bail and the presumption of guilt, as Ms. Jaising mentioned. And as Dr. Hussain noted, the process becomes the punishment. Even if a charge is groundless, a defendant can automatically be held for half a year. So what I want to emphasize here is that these are not domestic Indian law problems exclusively. There are issues under the Indian Constitution, which others know better than me, but these are also international human rights problems. And you don't need to take it from Human Rights Watch. On presumption of innocence, for instance, the United Nations Human Rights Committee, which monitors compliance with the ICCPR, has emphasized presumption of innocence is fundamental to the protection of human rights, imposes on the prosecution the burden of proving the charge beyond a reasonable doubt. Overbroad and vague language, criminalization of membership of a group. Well, in 2018, several United Nations human rights experts expressed concerns over terrorism charges being used to silence human rights defenders. They said the UAP's vague definition of unlawful activities, membership of terrorist organizations, confers discretionary powers upon state agencies, which weakens judicial oversight and diminishes civil liberties. Then in May 2020, eight UN special rapporteurs and the working group, the UN Working Group on Arbitrary Detention, raised concerns with the Indian government about 2019 amendments to the UAP, saying that, quote, the expansion of the designation of individuals as, quote, terrorists is problematic because the act fails to define a terrorist threat clearly and introduces broad discretion for the relevant authorities to label a person as a terrorist threat based on imprecise criteria. The 8 rapporteurs also said they were concerned about the use of the law to conflate human rights and civil society activities with terrorist activities and the fair trial and due process problems we just mentioned. They also, the 8 UN special rapporteurs, said the law would broaden potential discrimination against religious and other minorities, as well as human rights defenders, and that it's being used to target certain civil society actors on political, religious, or other unjustified grounds. I raise all this in conclusion to make it clear to the US audience of policymakers in Washington, US government officials, whether in Congress or the administration, that they can't take from India a rebuttal that this is a domestic problem that will be sorted out by India on its own. India is now out of compliance with international human rights law. And US officials have the right of any UN member state to raise those issues, just as India has the right to raise the United States human rights record if it violates international human rights law, which we've said it does in other instances. So that's the important use for all of these international standards to allow US policymakers to avoid the trap that is laid for them by Indian government officials, where they say, you can't criticize us because these are domestic issues. They are domestic issues, but they're also international human rights issues as well. And that is the avenue whereby congressional members and the administration can raise those issues. My recommendations are simple, that congressional members, members of Congress, use whatever interactions they have with the Indian government to raise these issues and state that we're very troubled that India appears to be deteriorating. They can talk about the United States having its own deteriorating political environment if they want. The point is, it's something of concern and members of Congress should raise it. And then the other thing that US members of Congress should and can do is to pressure the administration to speak up more about this deteriorating situation, whether it's by the incoming ambassador when he or she is chosen, or in interactions between the State Department or the NSA or during any kind of bilateral or multilateral meetings. There's no reason why 2 countries that have shared so much history and a democratic tradition cannot speak honestly with each other about the problems with human rights in the other country. It's within the rights of the United States government to raise these issues, and they should raise these issues with the government of India.